Companies Act, Section 101, Notice of Meeting. Section 101 of the Companies Act outlines the notice requirements for general meetings of a company. This section is crucial for ensuring that all stakeholders, particularly the members, shareholders, directors, and auditors of a company are properly informed about the date, time, and agenda of any general meetings, including annual general meetings, AGMs, and extraordinary general meetings, EGMs. The goal is to provide sufficient notice to allow the members to make arrangements to attend and participate in the meeting, while also outlining the procedures and exceptions for calling a meeting with shorter notice. Below is a detailed explanation of Section 101, covering the procedures, timeframes, and the parties entitled to receive notice of a meeting. Subsection 1. Requirement for notice and shortened notice. 1. General requirement for notice. A general meeting of a company, whether an AGM or an EGM, must be called by giving a minimum of 21 clear days' notice. This notice can be provided in writing or through electronic means as prescribed by the relevant rules under the Companies Act. The term clear days refers to the total number of days between the date of notice and the date of the meeting, excluding the day on which the notice is given and the day of the meeting itself. 2. Shortened notice with consent. While the standard notice period for a general meeting is 21 days, shorter notice can be given if the consent of the members is obtained in a prescribed manner. The specific conditions for shortened notice vary depending on the type of general meeting. A. Annual general meeting, AGM. In the case of an AGM, shorter notice can be given if 95% of the members entitled to vote at the AGM consent in writing or by electronic mode to the shorter notice. B. Other general meetings, EGM. For other general meetings, such as an EGM, the requirement is slightly more complex. If the company has share capital, members representing the majority in number of members entitled to vote, and who collectively represent at least 95% of the paid-up share capital giving a right to vote at the meeting, must consent to the shorter notice. If the company does not have share capital, the members entitled to vote must represent at least 95% of the total voting power exercisable at the meeting. See Special considerations for certain members. In cases where a member of the company is entitled to vote only on specific resolutions, rather than all the matters on the agenda, such members will only be counted for the purposes of the shortened notice in respect of the resolutions they are entitled to vote on. They will not be considered for those matters they do not have voting rights on. Subsection 2. Contents of the notice. 1. Required information in the notice. Every notice of a general meeting must contain certain essential details to ensure that all participants are well informed and prepared for the meeting. Place: the venue where the meeting will take place. This is important for physical meetings, especially when the company has offices in multiple locations. Date and day: the date and day of the week on which the meeting is scheduled to take place. This helps the members to mark the meeting on their calendars. Time: the hour of the meeting, so that members can plan their participation accordingly. Agenda: a statement specifying the business or matters that will be transacted during the meeting. This gives members the opportunity to review the issues to be discussed and prepare any questions or points they might wish to raise. The inclusion of this information ensures that the members are fully aware of the purpose and logistics of the meeting, allowing them to decide whether they will attend and to be adequately prepared for the discussions and decisions to be made. Subsection 3. Recipients of the notice. 1. Parties entitled to receive the notice. The following parties are entitled to receive the notice of the meeting. A. Members of the company. Every member of the company, including the legal representatives of deceased members or the assignee of an insolvent member, must receive notice of the meeting. This ensures that all shareholders are informed about the matters being discussed and can exercise their right to vote, where applicable. B. Auditors. The auditors of the company must be notified of the meeting. The auditors are important stakeholders as they may need to report on the company's financial statements and provide their opinions during the meeting. C. Directors. Every director of the company must receive the notice. Directors need to be aware of the meeting to participate in the discussions and decisions and to ensure proper governance of the company. The inclusion of these recipients in the notice distribution process ensures that the key stakeholders are kept informed and can contribute to the meeting as necessary. Subsection 4. Accidental omission to provide notice. 1. Effect of accidental omission or non-receipt of notice. In some cases, there may be an accidental omission in sending out the notice to a member or another entitled person, or the notice may not be received by the intended recipient. However, Section 101(4) provides that such an accidental omission or non-receipt of the notice will not invalidate the proceedings of the meeting. This provision ensures that minor errors in the notice distribution process do not result in the invalidation of the decisions made at the meeting, provided the notice was generally provided in the prescribed manner and to the majority of the entitled members. Objective and purpose of Section 101. 1. Ensuring transparency and proper governance. The primary objective of Section 101 is to ensure that members, directors, and auditors are properly informed about the date, time, place, and agenda of the company's general meetings. This ensures that meetings are conducted transparently and that all stakeholders have the opportunity to attend, participate, and vote on matters that affect the company's operations and governance. 2. Flexibility for urgent meetings. Section 101 also provides flexibility by allowing meetings to be called on shortened notice if the necessary consent is obtained from the majority of the members. This is particularly useful in situations where urgent decisions need to be made and the standard notice period cannot be met. 3. Ensuring validity of meeting proceedings. The provision for not invalidating meeting proceedings due to accidental omissions or non-receipt of notice protects the company from legal challenges arising from minor issues in the notice distribution process. This ensures that the business of the company can proceed without being disrupted by administrative errors. For more details, contact us.